The Supreme Court of Ohio addressed a variety of important legal issues when it conducted oral arguments in January 2026. The court heard 11 cases, including a city's use of a warrant to inspect rental properties and a mother's challenge to her endangering a child conviction. The court considered a challenge to the city of North Canton's rental license law. To rent property, the owner must schedule inspection of the rental units. If the owner refuses an inspection, the city can get a warrant from a court to inspect the property. CF Homes, which owns rental units in the city, challenged the law. They argued that to secure a warrant, the city needed probable cause to suspect there was a safety violation. The city requested a warrant to inspect CF Homes rental units, and Stark County Common Pleas issued one. CF Homes appealed the decision to the 5th District Court of Appeals. The appeals court affirmed the trial court's ruling. CF Homes appealed to the Supreme Court, arguing the law is unconstitutional. It argued the Ohio Constitution states that a search warrant cannot be issued to intrude in an occupied home unless the government can show something unlawful is happening inside.
So at the shallow end of the well, we look at the fact that the city provided no evidence whatsoever in its search warrant application, and in response, the homeowners provided ample evidence that there was no hazard or potential hazard. So that's the only evidence in the record. So your holding could be as shallow, if you will, as simply stating that the court mistakenly granted the warrant application and necessarily should have been denied. The only evidence that the city supplied in the record was that the owner politely declined the search and later in the briefs added that the home was, quote, aging.
The justices questioned the city and the Ohio Attorney General's office, which backed the city's argument that it did not need to know of a violation first before it could inspect the property.
So anything may become hazardous. That's the meaning of that.
Potentially, but particularly in this
Then
case,
any apartment could become hazardous.
many apartments could become hazardous over time, which is.
But some may not.
Some may not, that's correct.
And so the tenants are going to be invaded whether there's probable cause or not. Is that what you're saying?
No, we're merely saying that as long as you're promulgating a reasonable legislative reason to inspect for health and safety, you can satisfy the may become hazard standard under the statute. In this case, the fact that the apartment has never been searched before and is not a new structure is the showing that it may become hazardous, as although yes, all structures do age, as they get older, they do become more hazardous as well.
Amy Rodriguez was indicted on 11 counts of endangering a child for offenses allegedly committed against her stepson. The charges of the offenses took place over 3 years between 2018 and 2021. At the close of the trial, the jury was presented with a copy of the indictment in which each count was worded identically. The prosecutor also presented a timeline indicating when each type of alleged abuse occurred. The trial judge instructed the jury to consider each count separately and consider the evidence for each count. About 30 minutes into deliberation, the jury asked for clarification to explain which alleged act by Rodriguez applies to each count in the indictment. The trial court provided no further instruction. A few hours later, the jury found her guilty of 4 counts, listed as counts 2, 4, 6, and 10. The jury acquitted her of the rest. Rodriguez appealed her conviction to the 1st District Court of Appeals. The 1st District ruled the jury was clearly confused and did not receive enough information to determine which acts by Rodriguez applied to each count. The court overturned her conviction. The Hamilton County Prosecutor's Office asked the Supreme Court to overturn the 1st District's decision and find that, for multiple counts of the same crime, the state needs only to present evidence of separate crimes to support each conviction and does not need to list any further details in the information provided to the jury.
This had kind of a timeline, so periods of time. Was there any way the jury could correlate that with the counts of the indictment?
There's not on the trauma timeline references to counts 1, 2, or in this case 2, 4, 6, and 10, but there certainly are distinct types of abuse that are referenced in that trauma timeline. In this case, in the First District itself wrote in paragraph 48, the state charged Rodriguez with 11 counts of endangering children and presented evidence of 11 different types of abuse. And in the closing argument, the state linked each count to a specific allegation of abuse.
Rodriguez argues the jury's questions indicate it didn't know what conduct was the basis for each charge. Without that detail, she is unable to challenge her conviction because she cannot determine whether the state presented sufficient evidence for each count the jury found her guilty of committing.
They didn't just say, okay, fine, guilty of everything. They specified counts 2, 4, 6, and 10, and then entered acquittals on the other counts.
We do not know how they arrived at their verdicts. We know how they did not arrive at their verdicts. They did not arrive at the verdicts by aligning conduct with counts of indictment because they were never given direction how to do so.
They were in closing arguments, though, weren't they?
They were in closing arguments, and then if that differentiation had been effective, then they wouldn't have sent out those questions.
Chief Justice Sharon L. Kennedy announced the court will take the arguments under advisement and inform the parties of its decisions. You can follow these and other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.